Welcome back. The reason why the speaker is not here is because the speaker is over there. In the sense that he has some slides to show us, and of course it is much easier to be sitting over there. So, Francesco, you have the floor. Thank you very much.
Thank you. Thank you. Thank you so much. First of all, I would like to thank Professor Toniatti for inviting me and all the organizers, Professor Camassa, Davide Strazzari, for this very interesting workshop. It's a great honor to be here. Then I must make one preliminary remark. I don't know if my paper is interesting, perhaps not. In this case, I hope at least not to irritate you. But yet, as can be appreciated from the title, I'm sure its topic is very huge, it's very broad, with many different aspects. So, given the time available, let me apologize in advance for not analyzing all these aspects, but only some of them, what in fact I regard as the most important ones. And for the same reason, I'd like to start by getting straight to the point, which means to the fact that in India, laws governing matters related to individuals and their families, the so-called personal laws, have almost always differed from religion to religion. According to this system, the different religious communities are governed by their respective laws. These laws consist of either codified or uncodified rules regulating marriage, family, divorce, maintenance, adoption, and inheritance. In this context, and following what said Professor Harding, the degree of the Indian legal pluralism increased under the British colony. Christian and Muslim personal laws, for instance, underwent a significant process of reform and unification in the second half of the 18th century and during the 1930s, as can be seen from the screen. Why did the British decide to do that? For too many reasons, actually. The British normally avoided interfering with the personal laws of religious communities. For instance, in contrast to the unification of penal law, a similar step for the civil law was not taken. Rather than eliminating them, the religious personal laws were kept by the colonizers because, in doing so, they were able to sustain the colonial project by supporting the religious claims. On the other hand, the colonizers modified and unified some religion-based rules through the intervention of the state's legislation, which aimed at eliminating the practices seen as unjust or worse, as barbaric, as the British used to call them. But it is important to remember that the state was able to intervene only where there was a support of local elites, who often happened to be religious leaders as well. In this manner, in some ways, the colonizers were able to reshape religious rules through the interpretation of the British judges. This explains why the British decided to maintain and, if necessary, reinforce the legal pluralism in the area of personal law. But this also explains why the Indian activists who struggled for the independence were in favor of the replacement of the religion-based laws by a secular uniform civil code. Indeed, the uniform civil code was the subject of debate within the Constituent Assembly. Some of the founding fathers regarded this code as a step towards unity among the religious communities and hence as an instrument to make a common front against the British domination. Nevertheless, the supporters of the Uniform Civil Code did not prevail in the Constituent Assembly. Instead, in this matter, when the Indian Constitution was drafted, some sort of compromise was found. This compromise postponed the enactment of the Uniform Civil Code, which was mentioned in the 1950 Constitution, but only as a directive principle of the state policy, which, as you probably know, is not justiciable. This kind of principle is not enforceable by any court. Yet, this principle, as you can see from the screen requires the state to adopt a uniform civil code. The problem is that, until now, Article 44 of the Constitution has remained unimplemented. Moreover, soon after the independence was achieved, the legislature moved into the opposite direction. The decade after the independence saw a major codification and the modification process for the Hindu law. This process took shape through the so-called Hindu code bills that, together with the Hindu communities, still govern the personal laws of Buddhists, Jains, and Sikhs. Some regarded the Hindu code bills as the first step into the direction of the uniform civil code. Others, quite to the contrary, saw them as the first departure from the objective of Article 44 of the Constitution. And this is because the approval of the Uniform Civil Code would, in some way, imply a sort of secularization, the secularization of the personal law throughout the Indian territory. In this case, we should note that if you simply read some provisions of the 1950 Constitution, you can visualize the Indian constitutional design as a form of contemporary secular liberalism. If, on the contrary, the attention is focused on the other constitutional provisions, you see a different attitude. This is an attitude of a more traditional society in which individuals communicate with the state through their membership in a community, in a family, in a tribe, and of course, in a religion. As a result, in the Indian Constitution, we found a commixture of different voices. So far, the personal laws and legal pluralism are concerned, within the Indian constitutional system, it is in fact possible, from this point of view, of course, to identify two different approaches. On the one hand, there are those who see legal pluralism and religious personal laws as the root causes of discrimination and social injustice. For this reason, the respect of the principle of equality and human rights is believed to be achievable only through a secular agenda, which in practice is reflected into a strong call for a secular uniform civil code as required by the mentioned Article 44. In this sense, the attention is also focused on secularism, whose principle was incorporated into the preamble of the Constitution through the 42nd Amendment ratified in 1976. On the other hand, there are those who underscore the importance accorded by the Indian society to religions and religious communities, which reflects the idea of intersectionality between constitutional provision, or if you want, state's law, and religious traditions. In this sense, when and if possible, the state should try to reformulate religious practices from within, which means from within the religious communities, so that they can become compatible, or at least more compatible, with the principle of equality, human rights, and the need for a social justice as required by many constitutional provisions. The state can do this in two ways. First, it may collaborate with religious organizations and relative institutions, trying with them to redefine the meaning of religious rules. Second, the state may go even further, defining, interpreting, and regulating by itself the meaning of religious rules, which implies to determine what the proper practices of religion are required. What is at stake here is that the intersectionality approach sees traditions as instruments to formulate and legitimize reform, not only legal reform, but also social reforms. Through a process that gradually builds up a multi-religious overlapping consensus, this approach aims at affirming the pillars of liberal constitutionalism in such a way that these pillars become less and less strange in the Indian society, more and more effective, as Professor Ferrari said, within the religious communities. So, since the independence, this clash between these two approaches, secular agenda versus intersectionality, has produced an interesting role reversal. On one hand, the Parliament seems to disengage from its institutional role. It does not seem interested in implementing Article 44 of the Constitution. On the other hand, in the last 50 years, India has witnessed an intense judicial activism, seen as an engine of legal and social reforms. More precisely, the Uniform Civil Code has become a political battlefield, with the result that Article 44 is still far from being implemented. In turn, the intense judicial activity has been justified by the fact that India's legal system needs a uniform civil code, as if to say, until a uniform civil code is approved in matters of personal law, we, India judges, are in some way forced to replace the Parliament and do its job alone. Of course, we cannot make laws, but we can find a way of interpreting them. And this is because, in the words of the Supreme Court, the absence of such a uniform civil code, quote, cannot be accepted, otherwise every religion will have a right to decide different issues as a matter of its personal law, end quote. It should be noted that many times the judge's job consists in interpreting the religious personal laws in accordance with the constitutional provisions. So, compared to the Western legal systems, in India this situation produces serious problems with respect to the principle of separation, not only the separation between judiciary and legislative, but also, and above all, the separation between the state's authority and religious groups and relative institutions. It, in other words, regards the principle of secularism and religious freedom that, as declared by Article 25 of the Constitution, is related not only to freedom of conscience, but also to freedom, profession, practice, and the propagation of religion, which, I'm sure it's quite familiar to you, implies a certain degree of autonomy accorded to religious denominations in matters that fall within their competencies. This is even more relevant in relation to the so-called essential practice test, which has been used by the India judges and especially by the Supreme Court since the 50s. This test allows judges to initiate a judicial inquiry into whether or not a religious practice is, quote, essential for a religion, independent of what the creed's adherents themselves say about it. Naturally, for these very reasons, the essential test has met with fierce criticism. The judiciary, it is argued, in this matter, has neither the competence nor the legitimacy. After all, the Supreme Court of India is not the Supreme Court of Hinduism, Islam, or Christianity. In addition, the Constitution does not mention the expression essential religious practice. From here stem two questions. Where does the concept of an essential test come from, and why has the Supreme Court decided to use it so intensively? In order to respond to these questions, it is important to consider what was said during a session of the Constituent Assembly in 1948. India, I'm quoting, in India, the religious conceptions are so vast that they cover every aspect of life, from birth to death. And I think, from this point of view, almost nothing has changed since then. Besides, as is well known, India is one of the most complex and pluralistic societies in the world. It is in fact a land of vast variety of religions, which implies a vast variety of languages, customs, and living styles. India's unity is indeed based on its religious diversity. In any case, religion is an important source of the Indian society. So in this context, some point out that instead of the unification of the laws, the plurality is a real advantage. It allows individuals to choose among the different forums in order to achieve their goals. Now, the problem is that both the religious traditions and the legal plurality are not always positive in terms of human rights, principle of equality, and social justice. Religions and the legal pluralism can be used not only for these purposes, which are very important public purposes, but also against them. This problem was, in fact, already evident to the founding fathers, as demonstrated by the comparison. You have a sketch of this comparison on the screen, by the comparison between Article 19 and Article 25 of the Constitution. The former, Article 19, lists out the fundamental freedoms followed by the scope of reasonable restrictions. The latter, Article 25, is devoted to freedom of religion and starts off with limitations. So, since independence was achieved, one of the main problems was also how to restrain, or at least to reduce the harmful effects of some religious practices and relative rules. And in this sense, we can say that the Indian legal system has identified two leading ways to do so. The first one is to declare some religious practices as illegal and therefore contrary to the state's law, what seems to be fully achievable by implementing Article 44 of the Constitution. The second way is to reformulate religious tradition from within by declaring some practices as non-religious or at least non-essential characteristics of that religion, what seems to be affirmed by the jurisprudence of the Supreme Court. Moreover, in this context, India judges, and especially the Supreme Court, has tried to minimize the conflict between the free exercise of religion and the state's public purposes. In particular, they have sustained arguments against some religious practices, saying that these practices are not essential to a specific religion. And in doing so, judges many times engage in scriptural exegesis. Now, the reason behind this tendency is quite clear. If the constitutional provisions concerning personal law are not brought about by the Parliament in one massive legislative reform, then they must be brought about by other instruments. Through, for example, step-by-step reforms from within the religious traditions with the support of judicial activity. The fact is that, despite the judges' effort for the reinterpretation of some religious rules, sometimes these rules remain, in any case, incompatible with the state's public purposes. Thus, in cases like this, instead of underlying the serious disagreements between the religious rules and the public purposes, India judges have many times simply denied them. Take, for example, the famous law cases concerning the husband's obligation to provide maintenance for a Muslim divorced wife, where the Supreme Court tried to acquire the interpretative authority over the Holy Quran. And for this way, the court said that there is no contrast between some Islamic precepts and the state's provisions, such as those referring to Article 125 of the Indian Criminal Code procedure. It seems to me that with these decisions, the court wanted to offer Muslim communities internal reasons to justify husbands' obligations as affirmed by the state's law. In the light of the protest made by many Muslims organizations against the court's decisions, as well as the 1986 intervention of the parliament, the result, in my opinion, was not as good as it was supposed to. In addition, the essential test requires courts to have not just a general definition of religion. It also requires affirming whether a religious practice falls under that definition. And in making these determinations, India judges can, of course, favor some religions over others. Here, the example is made by the Hindutva case laws. As you probably know, some political parties which give the Hindu religion a central place in their ideology normally use the vernacular term Hindutva, claiming that it has a national patriotic connotation and is not just an equivalent of Hinduism. From 1980s and 1996, the Supreme Court delivered several decisions on that, saying that Hindu religion is indeed not just one of the religions of India. It represents, quote, the culture and the heritage of India, the India's social ethos and the way of life of the people in the subcontinent. As some Indian top legal minds criticized this jurisprudence, the Supreme Court issued a clarification, stating that those judgments had no intention of diluting the constitutional principle of secularism. The fact is that since the BJP party won the 2014 election, the problem of Hindutva has once again become relevant. With some of its allies, for example, RSS, the BJP party has in fact encouraged what is called the agenda of Hindutva, which sometimes implies the imposition of discordant measures, like those referring to the programs of Gar Baspi. These programs reflect a series of religious activities aiming to convert or reconvert, as they say, sometimes by force, non-Hindus to Hinduism. And this leads to focused attention of the long-standing issue of the anti-conversion laws, which affirm that no one can convert from one religion to another using force, allurement, or fraudulent means. This is, in fact, a very controversial issue, given that in the 1977, considering the constitutional validity of the anti-conversion laws of Orissa and Madhya Pradesh, the Supreme Court held that the right to propagate religion guaranteed by the Article 25 of the Constitution should be interpreted, quote, as not the right to convert another person to one's own religion, but the right to transmit or spread one's religion by an exposition of its tenet, end quote, which becomes even more relevant when taking into account two aspects. First, the distinction between the acts of converting and the acts of convincing people. Second, during the last decades, several Indian states have applied anti-conversion laws in order to prevent people from converting to Christianity and Islam. For this reason, the BJP party's intention to bring anti-conversion laws nationwide is now regarded with great suspicion by minority religions, including Christians and Muslims. The same, until a few years ago, the common position among human rights activists was a call for the enactment of a secular, uniform civil code. Instead, since the BJP came to the power, they prefer supporting reform from within the religious communities. And This is because in its 2014 election manifesto, the BJP promised the introduction of the Uniform Civil Code. So the minority religions are afraid that this Uniform Civil Code will be used against them for affirming a sort of Hindutva Uniform Civil Code. In conclusion, these examples are very important because they underline the connection between the discourse related to India as a nation and the discourse related to gender equality, human rights, and the need for a social justice and secularism. After all, in my opinion, the personal law issues and the constitutional protection of religious freedom can be explained only when taking into serious consideration this connection. Take, for example, the principle of secularism, which in India endorses the principle of non-establishment, but without advocating the separation of religion from the state. Put simply, in this case, secularism says no to established church and no to the policy of separation. This means that the state is to have no religion of its own. But this also means that the Indian constitutionalism gives a special status to religious communities in areas of specific importance, including family and personal laws. The only demand of secularism as mandated by the Indian Constitution is that the state must treat all religious creeds equally without discrimination. So, in this context, while many scholars agree that the personal laws are problematic in terms of human rights and the social reforms, the conclusion that they draw from this is not to call for a comprehensive uniform civil code. They suggest other means to accommodate religious diversity while respecting human rights and social justice. On the other hand, because the accommodation of religious rules also depends on religious communities, much will turn on the efforts of these communities, their scholars, jurists, leaders, to articulate approaches that make religious laws compatible with the constitutional principle. And in the light of these considerations, I wonder if, in a globalized world in which migration and diversification are becoming important topics, Western countries can learn from the Indian case in order to foster a legal model where different religions and beliefs can live and work together. Thank you.
Wider understanding and knowledge about Asian models, and we pass now on from very large subcontinent to another important experience, although much smaller, which is the one of Singapore. So, Professor Jamal, you have the floor.
Thank you.
I'm not moving just because I know that you have slides, so I can enjoy them from here.
Okay, well, thank you, everyone. I know that at least in terms of presentation, I stand between you and lunch, so I'll try to make this both interesting and brief. Let me also express my thanks to Professor Toniatti and the organizers for the invitation to be here today and in this very interesting company and in this very interesting seminar, and to make my presentation, which is about Singapore. And what I am going to try to do is focus as precisely as I can actually on the question of personal law, and indeed personal law as it has been expressed or protected in the Constitution of Singapore. And those will be my descriptive comments. And then I hope to make a few evaluative comments at the end, taking some inspiration from the question that Professor Ferrari gave us, his second question about whether these personal laws are effective in the case of Singapore in dealing with religious and cultural diversity. But first, some descriptive comments to present the case study. I start with a slightly broader context than just Singapore, but putting Southeast Asia on the map. And so you can see some of the religious diversity that is there in Southeast Asia, including, as you will see, in Singapore. And Professor Harding has already spoken about Malaysia. You can see the differences between Malaysia and Singapore and some of the regional context. When it comes to Singapore specifically, there's a lot of numbers here, so bear with me. But if you look at the bottom, and there's another chart, these are figures from the 2000 and then 2010 censuses. And if you look near the bottom, you can see the religious affiliation numbers. And these numbers show the way in which the breakdown happens in the context of Singapore and some of the movements, which haven't been too dramatic, but there has been some movement over time. And in particular, there's been an increase in those of no religion. And you'll see differences in the Buddhism and Taoism numbers, but that's probably because of the way in which they are counted. This one shows it slightly more clearly from 1980, 1990, and 2000. So the numbers, as I said, if you look at the numbers of Buddhism and Taoism, that seems to be dramatic shifts. This is not because there's been some massive conversion one way or the other, but the way in which these are sort of counted and the way people affiliate with them. Otherwise, you will see an increase from 1980 to from 1980 to 2000 in the Christian population, a small decrease, but marginally in the Muslim population, and again, small increase, but only marginally in the Hindu population. In terms of religious diversity, a recent study by the Pew Forum, and this is just choosing countries in Asia, showed that the Asia-Pacific region had some of the highest religious diversity in the world as a region. And as a country, Singapore was given the absolute highest rating for religious diversity. And this includes those of no religious affiliation, but Singapore was the absolute top highest in the world, according to their score out of 10. And this is, I think, relevant to the context, and I will speak about it a bit later on when I make my more evaluative comments. Let me then turn to the Constitution. So Article 15 of the Constitution is the article that deals with freedom of religion, and you can see the provision here in 15.1. And in 15.3, it is not just the freedom to practice, but to, as you can see, manage religious affairs, maintain institutions, acquire and own property, and hold it in administration, to administrate it in accordance with the law. I should also add that what I didn't put on here is Article 15.4, and Article 15.4 applies those same sorts of limits to the Article 15 rights, as we have just seen in the case of Article 25 of the Indian Constitution. In fact, it uses almost exactly the same language. And so this is India and Singapore, and so, as Professor Harding said, you see, it really is all the fault of the British, because this must have been this sort of legacy, okay? So this is what Article 15 is doing. As a result of which, one of my colleagues at the National University of Singapore, who is a public lawyer, has suggested this understanding, Professor Teo Lian has suggested this understanding of the way in which Singapore's constitution and Singapore's public law deal with religion. And as you can see from the quotation, she says, constitutional secularism is not anti-theistic, but is framed along agnostic or benevolent lines, where the state does not favor or disfavor religions, nor favor irreligion over religion. So that is the way that she would explain the constitutional structure. What is perhaps more relevant for the question of personal law comes in Articles 152 and 153 of the Constitution. And these are articles that speak to the minorities and special position of the Malays. And in particular, if you look at Article 152.2, you see a special provisions here for dealing with the Malay population, and in 153. Why is this the case? Well, it is the case because Singapore holds or considers that the Malay population is, as it were, the indigenous people of Singapore, and therefore they acknowledge and recognize this special status. What it also means is that this is the only community that has its personal religious law constitutionally protected, explicitly constitutionally protected. And I'll speak about other communities in a moment and how they operate, but this is the only one. So when we come to the question of constitutional protection of and for religious law, and indeed from religious law, there's only one in the Constitution, explicitly in the Constitution, but I'll come to how Article 15 is used for other communities later. And Article 153, as you can see, make this idea of special provision for regulating Muslim religious affairs and constituting a council to advise the president in matters of Muslim religion. This is only for this community. And just to be clear, in Singapore, and indeed, Professor Harding can speak to this, but in other parts of Southeast Asia as well, the conflation of Malay and Muslim is near identical, right? So the Malay population is overwhelmingly, I mean, to the tune of 98, 99% would affiliate with being Muslim, okay? There are, of course, other Muslim communities. So in Southeast Asia, you often refer to, say, Indian Muslims. But Malay and Muslim run almost coterminously, and that becomes relevant for what I might want to say later on. So in giving expression to Article 153, what has been done in the case of this constitutionally recognized, particularly constitutionally recognized personal law, the establishment of an act, the Administration of Muslim Law Act, or AMLA, and the existence of Sharia courts, not just Sharia courts, but a board of appeal, so there's sort of a Sharia appeal court, if you will, and within a body, which I should have put up here, what is called the Islamic Religious Council of Singapore, or by its Malay acronym MUIS, MUIS, okay? The Majalis Ugama Islam Singapura. Okay? In that institution, which is part of 153 when it says to make special provision and for constituting a council, this is the council, the Islamic Religious Council, MUIS as it's known, and they have a fatwa committee. And a fatwa committee, of course, is a committee that can issue these fatwas, which are, as it were, legal opinions about aspects of Muslim law. So this happens, as it were, by the expression of the Constitution. There is also, so that's one of the things which is distinctive, and I will come to some of the implications of that in a moment. I also wanted to speak about the interface with the regular or civil courts, because only the Muslim community has special religious courts. No other community has these special religious courts. In Malaysia, as we heard about from Professor Harding, there is this question about jurisdiction. In Singapore, the answer seems, as far as I can tell, to be more simple and more clear-cut. And I want to illustrate that with this case that I've given here, the Shafiq case. Let me tell you what the case involved. The case involved a Muslim couple, husband and wife, who held the property as joint tenants. The husband passes away, and according to common law joint tenancy, what should have happened then is that the wife would simply take the property as her property. That's what the joint tenancy provision would mean. But because they were Muslims, the question arose whether or not joint tenancy was compatible with Islamic law. And to make a long story short, there were two fatwas issued by Muis with respect to the question of the joint tenancy, ultimately saying that it was compatible. But what is more interesting for our purposes, and for the purposes of what I want to say today, is how the court responded to this. When the case went to the court, I mean, so what was the concern? The concern was a concern raised by other relatives that said, you know, if the property doesn't pass entirely to the wife, and it was their residential property, which was probably the major asset, then other heirs, according to Islamic law, might have had a share of this. But if it passes entirely to the wife, then they are excluded from the largest asset, okay, of some millions of dollars worth of, because this is, Singapore has high property prices, so millions of dollars worth of assets, right? This is why the case came up. What did the court do with respect to these fatwas? Well, the civil court said, we will be advised by these fatwas, but not bound by them. So the civil court basically said, we are deciding. We'll take this into account, but we are deciding. And this shows the relationship. So when you talk about constitutional protection, but it shows the relationship, I think, between of how this is dealt with practically before the civil courts. And as I said, this is only the case for the Sharia courts because there are no other state-recognized religiously defined courts in Singapore. Okay. One of the challenges that comes, and then I'm going to go on and speak about other communities later, but because of the constitutional role of the Malay and Muslim community, this deserves a bit of elaboration. One of the challenges that come, and this really speaks to the issue of freedom from religious personal laws. And I want to, and the short answer is that for Muslims in Singapore, whether they are Malay or not, there is not freedom from the religious personal law. You are bound by the religious personal law. So, for instance, Section 111 of AMLA talks about restrictions on the disposition of property by will. Traditional Islamic law has restrictions on testamentary disposition. Some of it has to go to what are called the Quranic heirs. And to give you another example about, or another instance, this is more anecdotal of how this becomes a problem. You see, there are concerns amongst some people in the Muslim community of Singapore now, precisely about testamentary disposition. So in the case of a couple that say has two children, say a son and a daughter, according to classical Islamic law, the son would get more than the daughter. If they are uncomfortable with that, what can they do? Well, you can't say, thank you very much, Singapore, but I would like my estate not to pass under Islamic law. That is not, you do not have the freedom to do that. So what they have done, and I understand this from talking to Muslim lawyers in practice, is a variety of different things. One is to try to employ particular devices that exist, especially in Southeast Asian understandings of Islamic law. They're called nuzuriya, hiba, ruqba. They are sort of, to summarize, inter vivos gifts. So the property is disposed of before the death happens, or actually they are posthumous inter vivos gifts. It's actually done after the person dies, but legally, the legal fiction is done just before. Okay? So that's one way in which they do it. It's not certain, it's not entirely legally certain, if that is actually going to be legally effective, if those devices can actually be trusted, counted upon, if there's a court challenge. So what else people are doing is sometimes removing property from Singapore. So instead of having an apartment in Singapore, they'll buy 2 apartments in Australia. And 1 apartment goes to the son and 1 apartment goes to the daughter. So you just take the assets out of the jurisdiction. That's not always practical because you're living and working in Singapore, and we never know exactly when we're going to die, so you can't exactly do the financial planning accurately. More radically, some people have also started to make statutory declarations that they are not Muslim. Now, that is also interesting because it's not entirely certain what the legal status of that will be. You know, the old argument, if it walks like a duck and it talks like a duck, it's a duck. If you grew up as a Muslim, you went, you know, you prayed as a Muslim, you lived your life as a Muslim, all of a sudden we die and we discover there's this statutory declaration that you made some time ago to say, I'm not a Muslim, then maybe they'll say, well, yes, you are. And it's not open to you to pick and choose. So this is one of the concerns in the case of Singapore, but it is actually a live concern. So there are Muslim lawyers who get, as it were, Muslim clients who come and say, we don't want our assets to be governed by the Administration of Muslim Law Act, or to the substantive law under that. What can we do? And sometimes they do statutory declarations. It's not the majority. It is some, but I'm just explaining the context of freedom from. It is also the case that if you're a Muslim in Singapore, to go to the second bullet point, you have to have your marriage registered. You cannot go to the registrar of marriages, the general registrar of marriages. You have to go to the registrar of Muslim marriages. And that means that the marriage has to be celebrated in a particular way. You do not have the option. You cannot say, I would prefer just to go to the registrar of marriages. That's not available to you. And so that is what, this is confirmed by this section of the Women's Charter. You see here, Muslims cannot get married under quote-unquote secular law, but must undertake Muslim marriages. Okay, let me speak a little bit about other communities. Now, these communities, other religious communities, these communities are not operating under, of course, Article 152, 153 of the Constitution. But what has happened in Singapore is that these other communities have, the government has made open to them to incorporate under either the Societies Act or the Companies Act. Typically, they use the Societies Act, which is more for charitable institutions. What is the challenge there? Well, the challenge there is that the government of Singapore retains the right to deregister an institution from the Societies Act. So that registration on the Societies Act is, as it were, at the consent of the government, and it can be withdrawn by the government. So they can say that we're no longer allowing you to operate under the Societies Act. You therefore lose the corporate capacity, that sort of notion of the corporate veil, for things like entering into employment contracts, holding property, doing a variety of other things. So there is some tension between that and Article 15, particularly Article 15.2, and 15.2 and 15.3 of the Constitution. So there is a certain tension there. There are also bodies which deal with for other religious communities. They're not quite the same as the Islamic Religious Council, as MUIS, but for the Sikh community and the Hindu community in Singapore, there are these bodies. Again, these operate to some extent out of the gift of the government, in the sense that the bodies exist, but the government retains the power to appoint certain people on these bodies, as they do, for example, for the Islamic Religious Council. So the president of MUIS, the head of MUIS, is appointed by the government of Singapore. There is also the capacity for certain communities to operate under private acts of parliament. And as we're in Italy, I thought I should talk about the Roman Catholic Archbishop. So here we have the Roman Catholic Archbishop Act, and this act is, of course, it's non-constitutional. It's an act of parliament, right? Non-constitutional status, but allows the Roman Catholic Archbishop, the Roman Catholic community under the Archbishop's control, to operate in Singapore. And so another of my colleagues has said here, for example, it allows the space for the Roman Catholic community to administer itself according to its own rules and to have a legal personality as a body corporate without imposing the management for the internal affairs of the church. So here, Singapore doesn't have institutions, Sharia courts that are by the state, which are going to say what the law is going to be. But for example, on the question of annulments of marriage, etc., the ecclesiastical court, the Catholic courts can operate, and they operate under here. So there is, in some senses, a little bit more freedom outside of the Muslim framework. I want to finally come to an important piece of legislation in Singapore called the Maintenance of Religious Harmony Act. Under this act, there is what is called the Presidential Council for Religious Harmony, which basically has strong regulatory powers in the case of what it's called mixing religion and politics. Now, that phrase might sound somewhat vague. It is deliberately vague. The government will tell you when you are mixing religion and politics excessively, and under the act, it has rather strong powers to sanction people. Here is, however, what we need to understand. This act has hardly ever been used. Most of the time, the way things are dealt with is, you sit down over a cup of tea and you have a conversation. That's not maybe as genteel as it sounds, because when you're sitting down with the government minister and they have the threat of the act, then, tea might have a different sort of meaning. But the fact is that the act has not been used very much, but it is there, and there's a part of the act, or the title of the act, which is very important, and I want to bring that up here, which is this notion of religious harmony. This question is, I think, the operating intellectual paradigm, this political paradigm that the government works on. Now, why is that relevant? Because if you go back to the context with the very high religious diversity that Singapore has, it is, and as Professor Toniatti has pointed out, in a very small geography, you can't sort of avoid, as it were, running into each other and interacting with each other. That said, and to correct sometimes the impression that Singapore might have in the minds of those who haven't had a chance to be there, it is a place where there is a very rich religious practice of very diverse types. People go to mosques, go to temples, go to churches. The religious holidays are celebrated. There is accommodation in the sense of, for instance, at my university, if you're Muslim, you want to go for the Friday prayers, you get a longer time, in the lunch break to go for the Friday prayers. Before the celebration of religious holidays, staff who are, say, Hindu will get some time off before Diwali. If you're Christian, you get time off before Christmas. So all of this happens. It is not a place which is, as it were, clamping down, but there are issues with respect to the violations of religious harmony. Now, I want to turn finally, in the last little bit, to talk about one of the other issues which was raised earlier, which is the use of arbitration. Singapore is a great supporter of arbitration. It's a great sort of fan of arbitration, particularly commercial arbitration. It wants to call itself an arbitration hub. It's trying to bring a lot of this arbitration activity into the country because, of course, it pays very good legal fees. And it is the case that religious law, not so much personal law now, can be used for commercial matters. It is not usually the case in the Singapore context that religious law can be used for personal law matters. You cannot have religious arbitration for personal law matters. So there is a distinction there. You could say, have a contract that was going to be governed according to Islamic law for a commercial matter, but it's a different thing if you want to arbitrate with respect to, say, marital disputes. That is the formal answer. Here is the, as it were, informal answer, particularly when it comes to the Sharia law. When people go to the Sharia courts, the court acts as a sort of informal mediator. So what they will do, and this is consistent with the way in which a lot of Islamic law courts will do, is they kind of bring the parties together. It's a less formal system, and they see if they can't work it out. And often this is with the help of the court officials. In fact, the judge, himself or herself, or himself in this case. If that can happen, so be it. Then the court can kind of bless that agreement. If not, then the court will have to give a decision. But that is done on an informal basis. And then finally, let me come before the end to the evaluative comments that I want to make. And that is to go back to the question that Professor Ferrari posed about whether or not these personal law regimes are effective to deal with religious and cultural diversity. Well, two final and concluding comments. One, on the one hand, as I've said, in Singapore, if you come there, it's very religiously diverse. There's a lot of religious practice that goes on. There is a fair degree of harmonious religious interaction, fairly harmonious religious interaction. You do not see some of the tensions that are unfortunately now affecting or infecting Malaysia, at least not to the same extent. But there is this problem, or potential problem. And it is particularly evident in those religious laws, those religious personal laws that are protected by the Constitution, that is to say Islamic personal law. And the problem is this. Within Singapore, there are different interpretations of Islam, different Muslim communities. They are able to maintain their own mosques, for example, their own places of worship. And MUIS is generally broad enough that they accept, even reluctantly, interpretations or communities which are non-mainstream. For example, the 12er Shia community and other communities in Singapore. And I say it is still within some limits because of the control. However, it becomes much more problematic when you are dealing with questions of personal law. Because then the Sharia courts normatize Shafi'i Sunni law as the basis, and deviations from that become more problematic. So and that seems to me to raise a bit of a tension with the constitutional guarantee. So it is, you have on the one hand the constitutional guarantees, but then because, and again it's part of the Constitution, because of 152 and 153, the personal law system becomes more strained, particularly for minority interpretations, and particularly, again, in the case of Muslim personal law. So that is all. Thank you very much.
Thank you very much, Arif, for this contribution, which completes the presentation this morning. And now I would like to open the floor for discussion. We have about 20 minutes, and we have a number of experiences that draw, that you're, Werner, also you? Yes. So I have... okay, we start now with, can you pass the microphone, please? Yes. We start with Elisa Junki.
Thank you. Just a comment that might seem a bit off the topic, but it's actually related to the speeches by Professor Hardin and Professor Alicina. Professor Alicina was mentioning that judicial activism has been used as a sort of engine to reforms in India. And as you may know, certainly Werner Mensky and Prakash Shah know very, very well, Pakistan is possibly the country where religious-based judicial activism is most pronounced. And in Pakistan, at least, but I guess that the causes are different in India, the judiciary sort of works, reform the law, even disapply rules, and acts in a way on behalf of the state, as a way to react to the parliament's paralysis, internal paralysis, and when it comes to very contentious issues. But I think the most interesting aspect about Indian and Pakistani judicial activism is that it is secular judges who actually do what you call the scriptural exegesis. Their background is quite secular. They've gone through schools of law that have a curriculum quite similar to ours, and yet they refer to different sources and they often rejects some classical methodologies like the theory of aggregation, etc., etc. And this raises the topic, and maybe this is off the topic today, what is considered as religion by the courts of justice, which are have been mentioned by all the speakers this morning. And also Professor Jamal was mentioning the problem of the differing interpretations of what Islam is and Islamic law is, particularly when it comes to secular judges, or even nowadays on the web, secular activists or people who do not have a deep knowledge of Islam. And in the cases I studied in Pakistan, I sort of saw two different attitudes by the judiciary. First of all, Islam or Islamic law seen as a set of, let's say, principles, such as justice, maslaha, etc., as a way to widen women's rights in the domestic sphere. But then I saw by those very judges a very different attitude when it came to minority rights. Before, when Professor Hardin was talking about the Halal case, that brought to my mind a law enacted in Pakistan in 1984, which barred the Ahmadi community from using Islamic terms for their religion. The Ahmadiyya community is considered as non-Islamic by Pakistani law. And it brought it to my mind because a few, they cannot use, for example, the term masjid for their mosque, etc., etc. And they cannot even salute themselves with what are considered as being Islamic greetings, such as salam alaikum, alaikum assalam. And a few years later, I believe it was 1993, the Federal Sharia Court in Pakistan addressed a petition against that law. And in that petition, that I think was very interesting, the Federal Sharia Court, that in other cases pertaining to women's rights, had been referring to general principle of equality and non-discrimination, actually referred to Islam as a brand that should be protected by copyright laws, sort of participating in a trend that exists in the Muslim countries of turning Islam into an identifiable object that have rigid rules, rigid characteristics. And so it's the very same judges within the Federal Sharia Court that apply a different concept of Islam when it comes to women's rights in the domestic sphere or minority rights. So I think this would be interesting if we can today or tomorrow to discuss also what religion are the parliaments, the constitutions, the judiciary talking about. Thank you.
Thank you very much. Lorenzo?
I have a very short question for Arif. Because the Religious Harmony Act was very intriguing to me. And you mentioned that it has been hardly applied. And yet, by saying this, you did open the door to my curiosity, at least. And I wonder, well, when did it apply? So that's a very simple question, but I would like to hear more about an example of application of this act, if at all.
Okay, since the microphone is there, Prakash.
Oh, okay. Am I jumping the queue? Thank you.
Yes,
Thank you very much to all the presenters for wonderful presentations. I just wanted to say something at this point, because I think we kind of at the end of the Asian section, if you like, of the one of the things that strikes me, and this is perhaps not untypical of conferences on religion and law, is that we have certain assumptions about what religion is, and we haven't really gone into that thing, which is a problem. So that problem, particularly as it might confront the Asian scenario or scene, right? Would we say that religions there are religions in Asia, but they are of a different kind to Western religions or the Semitic religions? Or would we say that, in fact, Asia has no, as some people claim, Asia has no religion, right? Because that would fundamentally affect the hypotheses of the conference, or at least the conference questions. It would also affect how we regard the role of the secular state. And there, I think we can go back to what Silvio Ferrari and Andrew Harding was saying, and also Arif, about the role of Europe, but also, no, I don't want to say the fault of the British, but the export by Europe of certain ideas of law and state. together with ideas of religion and secularism. And it seems as though today we are living, or at least the Asian countries are living with a particular kind of inheritance which was exported to them from Europe, right? And how the European colonizers or explorers and so on conceptualized the reality of Asian countries in their terms. Of course, it's possible to say, as Andrew Harding, I think, brilliantly said, that there are traditions of pluralism which have existed in Asian experience for centuries, right? And there are some amazing research possibilities there about how Asians have lived together, despite or in spite of their differences, for centuries without the need for the secular state, which the colonial state became, so if you like, an intervener in the guise of, the secular state. So then the other question, which is interesting, which we're asking for Europe today, is that can those European-influenced secular states, which were, if you like, introduced in Asia, have any application today in the European context? Of course, they were European creations to some extent, and Asians today live with that inheritance. But actually, today in Europe, we wouldn't really readily accept that. And I think Silvio Ferrari was hinting at that, right? That today our ideas of equality and so on within a secular context have changed so much in the last 200 years that today the idea of personal laws seems impossible to conceptualize in a European context. People talk about it, but nobody really wants it, right? The Archbishop of Canterbury, as he then was, or Dr. Williams, who was once upon a time Archbishop of Canterbury, tried to introduce the idea, but he was knocked back. People don't really want to countenance these things. So one of the interesting, I think, meta questions for us today is, what has changed in Europe that today we wouldn't conceptualize very easily of the possibilities of personal law, whereas at one time, at the height of European exploration and colonization, Europe was exporting these models to other parts of the world. Okay, I'll stop there.
Now, thank you very much. As you pass the microphone to Professor Mensky, let me just make sure that I say that we are not supposed to extinguish our interest for Asia this morning. Of course, questions about Asia are welcome to continue in the afternoon as well as tomorrow. And further, I would like to say that one of the reasons for asking Elisa Giunchi, who is an expert about Asia, to chair this afternoon is precisely to continue comparison when European or West Asian experiences are going to be presented. Werner?
Yeah, my neighbor says we should maybe address the questions first, but I actually think I want to connect directly to what Prakash has just said. So you were asking what has changed in Europe. Yeah? I would go further. I would ask also what has changed in the world. So when Andrew talks about the new battles, if you like, in Malaysian law, over the distribution between Muslims and non-Muslims, or we look at what goes on in Pakistan, or we look at what goes on in Indian law also, you see that this is influenced to some extent by global developments, by the new context now of the global war on terror and all these things. And so national developments in the reassessment of personal law positions also have to do with that. And several of our speakers, I think, have very helpfully identified that all of this, of course, has to do with identity also, very clear. But religion also has to do, and Arif, you brought this out so well, with economics. Yeah? There's a lot of economic relationship, and you have the Shabanu case here, which is all about money. Yeah? And so Indian law very clearly forced Muslim ex-husbands to provide for their divorced wives. No? But you know, what we haven't picked up yet is that this poses now a new challenge to Indian law, because what should happen to Indian ex-husbands who are Hindu? They ought to have the same obligation. Otherwise, you have an unequal law. Muslim husbands have to pay more at the moment than Hindu husbands. Yeah? So there's a new challenge that a Hindu-dominated government doesn't even want to address. Yeah? And so, you know, these are things that nobody talks about, but in a conference here, in a safe space, we can raise it. In India, I think it would be.
By all means.
A little tricky.
By all means, yes.
And what I wanted to add is also that in the Indian context in particular, because it's such a massive jurisdiction, we have to be conscious of the welfare state context. This doesn't go for little Singapore, yeah? But in India, the constitutional obligation to get it right in terms of redistribution of assets is so strong. And again, there are huge debates about that, completely unrelated, it seems, to religion, but they are related to these religious dimensions. Yeah?
Andrew also had raised his hand for asking a question, I understand. So you have two tasks. You have to ask a question, then you have to answer many questions.
I think they're actually related to each other, but okay, thanks. Now, I think the first point is about judicial activism and the role of the courts that you were asking about. I think this is very, very interesting. I mean, Werner probably knows much more about this than I do, but I mean, for about 200 years, the Privy Council in London was happily deciding cases on Islamic law and Hindu law. I assume with disastrous effects, because it's always the fault of the British. But so, I mean, it's not impossible for, shall we say, common law courts or civil courts to decide these questions. Whether they do it well is another matter, obviously. Now, you can see a complete contrast here between Malaysia and Singapore, because whereas in Singapore, as Arif said, you know, the court happily takes on the role of judging whether a fatwa is correct or not. You know, there's a different attitude in Malaysia. If a question of Islamic law arises, that is for the Sharia court to decide, even sometimes if it's a purely jurisdictional question, which is not very logical, actually. In the Allah case, the leading judgment in the Court of Appeal even goes so far as to say, of course it is not up to this court to decide theological questions. The judge then spends 27 pages deciding the theological question. You know, not only that, but even sometimes when they're deciding constitutional cases or cases arising in the common law itself, they will use Islamic texts and precedents to decide those issues. So it's a very, very confusing picture that arises. Now, I totally agree with everything that Werner said. I've no problem with any of that. But the question that I wanted to raise really relates, and I think this is very adjacent to Professor Alicino's presentation, because this issue of essential practice, I think, is extremely important. And this came up very directly in the Allah case, because I was involved in the litigation in this case. And the court actually used the idea of essential practice, relying on Indian precedents, to say that the use of Allah in Catholicism is not part of essential practice. Well, of course it's not part of essential practice. I mean, that's obvious. But my point was, why is this question even relevant? If you have freedom of religion, why don't you have freedom to practice your religion in the way that you choose to practice your religion? If you and your community have been doing it for 500 years, and the Archbishop himself has no objection to that, and I assume the Pope has no objection, why is that a problem? So I object to the essential practice idea, not quite for the reason that you put forward, but for the reason that it's contrary to the freedom of religion. So I just wanted your comment on that.
Of course, yes.
It was part of a question. It seems to me that the essential practice is used also by some European courts. In the Begum case in the UK, the court called experts of Islamic law to understand whether the clothing, the dressing way of the young student was Islamic or was not Islamic, and more precisely, if that way was central to, that way of dressing was central to Islamic religion or not. And so I don't see much difference here from what happened in the UK in the case of Begum and what happens in some Asian countries where they use this essential practice test.
We have about 6 minutes before we go. So any
yes, in relation to the essential practice question,
yes,
yeah. I mean, I completely concur with Silvio's response. I think that what will be different in the Asian context is that Asian judges simply lack the criteria to consistently address the questions the way in which Europeans have, because it's basically an inheritance of the secular state, which was developed in Europe. And so once that idea is this idea of secular state and essential practices that goes with it, I think it's a package. Goes into the Asian context, it will collapse in meaning because the background ideas which enable judges to make sense and people to make sense of these ideas is completely lacking. And that's why you will get inconsistencies, massive inconsistencies in relation to the essential practices tests and cognate tests like that. You know, I mean, now Indian judges have to decide whether or not women can enter certain temples and whether or not restriction of women at certain times or certain times of the month or whatever is because of an essential practice in Hinduism is just a completely nonsensical question. It doesn't make sense in the Indian traditions, but it is frequently asked. This kind of question is frequently asked by the Indian courts, you know, without it having any bearing on traditional Indian practices.
Can't resist.
I think there's a basic difference in the Shah Banu case and in what is discussed in Europe. It's about legitimacy. In Shah Banu, it was the legitimacy of this Hindu-dominated Supreme Court addressing questions of Sharia. And it rings much with the politics, where in Europe, it's not a matter of legitimacy. It's a matter of practicing sovereignty, and it's about expert testimony. So I think this makes a very essential difference.
And then we start answering.
Since we have a minute or two, we've talked about judicial activism, but I'm not quite convinced that we should only talk about judicial activism, because in Indian law, but also in Pakistani law, and at the moment in Bangladeshi law also, you have a very intricate interaction between parliamentary activity or non-activity and what judges are doing. So it's an interplay of these two parties. And you can see this in India very clearly. It's a step-by-step. Parliament does something, but they do it nowadays not with big codifications, but with tiny little amendments that take, 5 words, and we don't even see them. So, for example, the Christian law in India was changed, 2 days after the Daniel Latifi case, because there were no riots after the Daniel Latifi case, so they also changed the Christian law. And nobody even has noticed that, And so I've spotted that there are quite strategic moments where certain things happen, not only in South Asia. But I wanted to add something else. You've mentioned or claimed almost that nothing much has happened on the Uniform Civil Code. No, I think something very important has happened. Namely that, as you showed, the activists realize that this is now Hindutva agenda. We don't want to subscribe to that. But what has happened in the meantime is that the various personal laws that we have in India have actually been harmonized over the last 30, 40 years. So now it doesn't make a difference whether you're a Hindu woman or a Muslim woman or a Christian woman. Everybody marries according to custom. Everybody has so many grounds for divorce. Everybody not yet is entitled to certain financial provisions on divorce, and so on and so on. So it's a very subtle step-by-step harmonization of the whole thing. So we have, in fact, a uniform civil code, but not in the form in which it is imagined if you just look at Article 44. No? And people are beginning to buy that. I'm seeing now that some new research coming out of India is saying, oh, that's what it is. No? So the moon looks different.
I wonder if the Supreme Court will buy it. Any more? Okay, so we can start a round of answers to the various questions and comments which have been put forward. We start from you. No?
Okay. Thank you. Thank you for the questions. Professor Lisa Junki said that talked about what is religion and the definition of religion. This is a very huge problem, especially in Asia. A few years ago, Professor Ferrari wrote an article saying that we can live better without defining what is religion. But the problem is, as I said just a week ago, as an academics, we can have a luxury not to define a religion. But you have to consider that the freedom of religion is many times related to, for example, tax exempt or asylum seekers protection. So judges and lawyers sometimes have to define what is religion in order to define what is protected by religious freedom. So this is a very controversial issue, especially if you consider the fact that there is a very different idea, in my opinion, what is religion in the West or in Asia. A friend of mine, Indian, used to say that Hinduism, for example, is not a religion. It's a palace with different rooms. But it is not just a religion, as the Supreme Court said. So it's very important, but it's very difficult. And I have to confess that I have no answer on that, what is religion. But judicial activism. The problem about the Article 44 of the Constitution is that the essential practice test and the scriptural exegesis used by the Supreme Court has been justified by the fact that the Article 44 is unimplemented. So the Article 44 is used by the Supreme Court to justify this very important jurisprudence in order to reform from within the religious communities and making law compatible, religious law, religious personal law compatible with the constitutional provision. So I completely agree with you. And yes, the Parliament sometimes has made some law, some intervention, but always after the Supreme Court judgment. So there is this interaction. But the problem is that the article, yes, Article 44 of the Constitution is a direct principle of the policy, so it's not justiciable, but it's still there. So there is, I agree with you. The essential last question, I think. What was said by Professor Ferrari, I discovered, reading a judgment of the Supreme Court of India, that in defining religion or in justifying its definition of religion, it referred to the jurisprudence of the Supreme Court of Canada. It's very important. I was so surprised to do that. So the essential practice is not called as the Supreme Court used to be, but used to do, but of India. But the essential practice, in some ways, even in Canada, is used. And you know very well that in Canada there is a huge debate about the definition of religion, considering this shift. They have moved from a subjective definition to an objective definition of religion. I think.
Okay, thank you very much. You want to take the floor now, or yeah?
I just got a very brief comment about this question of what is religion, which I want to base on an example, which is that in Singapore there is a very strong law on open burning, for environmental reasons. There's one important exception to this law, which is that it's okay to burn openly if it's done in pursuit of religious practice. This was introduced because large numbers of Chinese people on a festival called Festival of Hungry Ghosts burn openly large quantities of material to the spirits, and it's environmentally hazardous. This is allowed even when the government itself announces that it is hazardous to go outside because PSI levels are now at 300 plus, which is ultra hazardous. So apparently this is okay. Now, this has nothing to do with belief systems. This is not religion, in fact, even though the statute, it's based statutorily on religion. It is to do with traditional practice of a particular community. And it is allowed not because anybody seriously subscribes to the beliefs, not at the government level at any rate, but because it is traditional in that particular community. So this is very, very strong in Asia, but it's not based on one's right to have particular beliefs as an individual. That's my conclusion. I don't know if Arif agrees with that. But sorry, this one bit here. Yeah.
Well, let me, before coming to that point, there's answer Lorenzo's question, and then I can make a comment about the point that Elissa made first. So on the Maintenance of Religious Harmony Act, the restraining orders, which is the strongest power, as far as I just checked my paper, I think it's never been used, the restraining order. However, religious harmony as an idea is applied, and I'll give you two instances of that, but they don't tend to use their Maintenance of Religious Harmony Act, the sort of the heavy club, but they use other acts. Those acts include the Publication Act, more strongly the Penal Code, and even more strongly the Sedition Act. Okay? So they use other acts. One example was, and sometimes it's done even outside of these acts, but I'll give you one example with the act, when the act was used, and one without. So, and I don't remember the issue, Andrew might recall, but this was in the last maybe couple of years. The Archbishop had said something that the government was uncomfortable with.
In Singapore?
In Singapore.
Which Archbishop?
The Catholic Archbishop. The Catholic Archbishop. And what happened there was they didn't use any acts. But the minister met the Archbishop, and they had a cup of tea. And then, a few days later, the Archbishop, issued there was a news report that the Archbishop had sort of had a change of mind, and, everything was fine. Okay? More recently, there was a young boy, about 16, 17 years old, who had this blog. And in this blog, he apparently said something that was offensive to Christians. Now, some Christians read it and weren't offended, but, some may have been offended, etc. He was prosecuted. And they used the Penal Code, and I think the Publication Act. I think it was the Publication Act. But he was prosecuted. They did not use the Maintenance of Religious Harmony Act, but they used others. So the idea of religious harmony is, as it were, invoked and enforced, but not always with the heavy club of the MHRA. Okay. Or the Internal Security Act, yeah, or the Internal Security.
I suppose the very fact of going to court would not be harmonious.
Yes, well, yeah, I suppose, yeah. So cups of tea are maybe more harmonious, yeah, depending on what they put in the tea. But anyway, but then on to the other point, to Alyssa's point about the diversity of Muslim interpretations. I think this is exactly one of the places where things can get rather sticky. In Singapore, certainly it's the case, but I think even more so, and Andrew can perhaps speak to this if what I'm saying is wrong, even more so in the case of Malaysia. Malaysia now, because in 1996 there was a fatwa in Malaysia. Malaysia also has institutions like the Islamic Religious Council of Singapore, but they're like JPs and others that operate in Malaysia. And there was a fatwa that declared Shiism to be a deviant sect. Okay? For a number of years, this didn't mean a whole lot, but the certain states in Malaysia, as he said, it's a state matter, have now started to gazette laws about Shiism and the practice of Shiism, whether it's the proselytization or even practice. I think Kedah has done this, maybe Perak has done this. I don't know which of the states have done it. I think Kedah definitely has done this. This is a problem now because in the recent past, about 200 people, 200 Shias in Malaysia were sort of rounded up and arrested for celebrating a Shia holiday. I mean, they weren't doing anything to anybody else, but it's like, you know, they kind of make a joke sometimes in the United States. You can be pulled over for driving while black. This is being arrested for being Shia. And this was the context. So it's definitely an issue in this part of the world. Not so much, again, in Singapore, but I think more so in Malaysia. And that's why Singapore is, I think, particularly concerned about, as it were, religious harmony, because they see in the context around them that things are getting rather sticky.
Have some answers?
Well, I mean, I agree with Arif that it's gone very much further in Malaysia, and I think even people in government now are starting to say that, you know, we give these sort of millions or billions of ringgit to this JAKIM, this kind of religious police organization, and what do they do except raise ridiculous issues and arrest innocent people for the most minor things? I mean, for example, emptying a nightclub, separating the Muslims from the non-Muslims, and then arresting all the Muslims for being indecently dressed, which was very embarrassing to the tourist industry, amongst other things. And, you know, lying in wait for celebrities at hotels who might conceivably be found in a room with a person of the opposite sex, so that they can create a scandal and no doubt a lot of, you know, backhanders from the media in terms of selling newspapers, making a raid on a Protestant church because Muslims had been invited to a dinner that was some sort of charity do on the assumption that they were proselytizing people. I mean, this is the sort of thing that goes on every single day, and people are absolutely fed up of it.
Yes, well, we're not fed up for two reasons. One, because we are here just because we want to listen to all such considerations, and secondly, because the coffee break was not enough to feed us up, and so we perhaps need lunch, and that's what we're going to have now. I don't want to make any final remark, so I'll just ask you to be here, supposedly at 2:15, but I know there will be some 10 minutes of patience. Am I correct, Elisa? It is. We are due to be back at 2:15, but I know you'll be generous enough to wait until 2:25 to start. So, thanks to her, we can have 1 hour and 10 minutes for lunch, and enjoy your lunch, and I'll see you then back in the afternoon.